Thank you. I want to go ahead and welcome you again to the Alpha Staff webinar series. Today's topic, as you see on the screen, is Recent Employment Regulations and Risks, presented by Donald C. Works III with Jackson Lewis. We'll get started in just a moment. So I would like to introduce our presenter today, Donald C. Works. I call him Don. I hope that's okay, Don.
Yes, that's great. When I'm Donald, I'm in trouble, so that's good.
That's kind of how I was with my parents. If you got the middle name, you really were in trouble.
Exactly.
But I've known Don for several years and have always enjoyed working with him. He is a managing principal with Jackson Lewis in the Orlando office. He specializes in all areas of employment law, and he does represent management. He carries a Bachelor of Science degree from Auburn University in Personnel Management and Industrial Relations, as well as his Juris Doctorate from the University of Miami. He does serve on the board of HR Florida as a State Director of Government Affairs and has held the role of past president of the Central Florida HR Association, as well as the HR Association of Broward County. He carries his SHRM Senior Certified Professional credential, as well as his HRCI Senior Professional in HR. He frequently presents and publishes articles on wage and hour laws, as well as other employment law topics. And he is recognized by his peers in several publications, a couple that are mentioned there, The Best Lawyers in America and Florida's Super Lawyers. So you are in great hands today. And Don, without further ado, I'll turn it over to you.
Thank you very much, Sandy, and good afternoon, everyone. Well, we have a lot to cover today. There's been a lot happening on the employment front, and therefore we've got a lot to brief you on and get you up to date on so that you're prepared to deal with these issues in your workplace. Our agenda includes, starting off, we're going to talk about employment in general in the United States, some trends we're seeing, changes in leadership at the Department of Labor, some new Department of Labor opinion letters that will be of interest to you, I'm sure, the new overtime rule, recent trends in pay equity class actions, off-the-clock class actions, Fair Credit Reporting Act class actions, and additional developments, as you can see on the next slide, the Supreme Court and what they're doing in terms of Title VII, some big wins and losses in the courts for employers and by employees with the EEOC. We're going to give an update on the EEO-1 pay data reporting. And then finally, we'll wrap it up with a discussion of trends in federal arbitration rules, Me Too movement, and a labor update with the board, the National Labor Relations Board. So as you can see, we've got a lot of topics to cover. So this is going to be rather fast and furious, and I'll do my best to give you what you need to know to help you deal with your employees in the workplace. As Sandy said, if there are questions at the end, we'll be happy to take them. So looking at U.S. employment in general, as you all know better than anyone, there has been a really strong economy in terms of employment. There were 164,000 new jobs created in July, 130,000 created in August. Unemployment is holding at just 3.7%. And while monthly job growth is a little bit slower this year than it was last year, it's still at a very high pace. And you're probably feeling this in more ways than one, especially in terms of recruiting and hiring. It's getting more and more difficult to find qualified candidates. One thing we are seeing is that the gains in employment continue to be primarily in the service sector. So that's of interest. Doesn't look like manufacturing may be coming back as much as expected. Other trends you can see in the next slide. Average hourly wages have increased to an all-time high of $23.59 per hour. And what we see employers doing in terms of budgeting for next year, there are slight increases in pay, just 0.1%. So while wage growth is accelerating, it's not accelerating as much as we would expect given the record low unemployment. That said, we do have all-time high hourly wages at $23.59. So some very positive news in terms of employment data in the United States over the last couple months. I know it makes it tough for you in hiring, but it's good news overall and certainly good news for our economy and our businesses. The next thing I'd like to talk about just very briefly is what's happening at the Department of Labor. As you can see, Alex Acosta, who you all may recall was the Secretary of Labor, he got caught up in the Jeffrey Epstein scandal. Apparently, he was involved as a U.S. attorney in cutting the plea deal with Jeffrey Epstein in the Southern District of Florida years ago. And as part of what was going on over the summer with the Epstein scandal, Alex Acosta did decide to resign as the Secretary of Labor. At that time, Patrick Pizzella, who was the Labor Deputy Secretary, became acting Secretary. And he continues to serve in that role. Now, President Trump has named or nominated a management side attorney, Eugene Scalia, as his pick to permanently fill the role. So until Attorney Scalia is confirmed by the Senate as the new Labor Secretary, what do we expect? Well, as you can see in the next slide, we think things are going to proceed as normal. One of the things that Acting Secretary Pizzella has already noted, and we've seen him following through on this, is that he's committing to getting key rules finalized by the end of 2019. So just because we're in this interim period between Secretary of Labor Acosta and likely Secretary of Labor Scalia doesn't mean that nothing's happening at the Department of Labor. In fact, quite a few things are happening. So what do we expect when Eugene Scalia, hopefully, is nominated by this or confirmed by the Senate? As you can see in the next slide, there's a little bit of background on him. You probably recognize the last name. He is the son of our late U.S. Supreme Court Justice, Antonin Scalia. He is considered pro-business, which is why I say hopefully he is confirmed by the Senate. He does have a vast amount of experience working for the federal government. He was the labor solicitor under President George W. Bush. And for those of you who don't know, the labor solicitor is the lead attorney for the Department of Labor on a national level. So he has got a wealth of experience with labor and employment laws and extensive experience as a management side employment attorney. He's currently a partner at Gibson, Dunn & Crutcher in D.C. and is part of their labor and employment practice group and does administrative law and regulatory work as well. So very well qualified, should likely be confirmed by the Senate, and that would be a good thing for business. What are some key issues we expect the acting secretary and likely Secretary Scalia to be focused on at the DOL in the next year or so? Well, first at OSHA, we think that they're going to focus more of their efforts on compliance assistance to balance out their enforcement activities. So in other words, we may be seeing what we used to see some 15, 20 years ago, where OSHA would be doing field visits, but not to investigate, not to inspect your workplace, instead trying to help you come into compliance with current standards and new standards that might be published. So a more proactive, interactive relationship with business in this country, trying to help you be in compliance. Other department issues, implementation of the overtime rule, which we're going to be talking about later. They're also looking at a proposed joint employer rule, which would narrow the Fair Labor Standards Act definition of joint employer, and it would also modify the definition of regular rate of pay that's used to calculate overtime premiums. And I'll come back to that in just a moment. Finally, we think that the department is going to go back out and seek comments on the Family and Medical Leave Act and how it can be improved to better protect workers, but also to reduce the administrative burden on you, the employers. So a lot of things on the agenda for the DOL in the coming months. Now, that in mind, I want to talk about a few opinion letters that have come out of the Wage and Hour Division of the Department of Labor in the last several months. I don't know how many of you know the background on these opinion letters, but for years, the Wage and Hour Division issued opinion letters to employers. So if you had a question, for example, about whether or not an employee was exempt or non-exempt, or how they should be paid, or how to calculate overtime, you could write a letter to the acting administrator at the Wage and Hour Division, and you would get back an opinion letter telling you what their opinion was in terms of how you should comply with the law. During the Obama administration, they abandoned the practice of issuing opinion letters. That has changed, however. In 2017, the DOL Wage Hour Division began issuing opinion letters again. Now, what is the significance of this? Well, as some of you unfortunately may know, if a claim is brought under the Fair Labor Standards Act and somebody prevails, they are entitled to recover not only minimum wage or overtime, but an equal amount as liquidated damages. So there's in effect a doubling up of whatever might be due in the lawsuit that's filed by the employee. There's one defense that an employer can raise to that liquidated damage provision, and that defense is called a good faith defense. And the good faith defense is just this: if you were relying upon an opinion of your counsel or an opinion from the Wage and Hour Division of the Department of Labor when you implemented whatever the decision in question was, and you still ended up violating the law, then you have a good faith defense to the cause of action brought by the employee, rather than being liable for 2 times the amount that might be due. You're only liable for the amount that actually is due. So opinion letters are very significant because if you rely on them, you'll have that good faith defense. Having said this, if any of you have questions about a particular wage and hour issue, of course you should consult with Alpha staff first, but then maybe working with Alpha staff or your counsel, you might consider asking for a formal opinion letter. They do come in handy later on. So let's look at a few of the opinion letters that have been issued just in the last 12 months or so. This first one is under the Fair Labor Standards Act. It's opinion letter number 7. And basically what it deals with is when you're calculating overtime, do you have to include bonuses that are paid to the employee in the regular rate of pay? And the rule is simply this, that if a bonus is non-discretionary, then it has to be included in calculating the regular rate of pay. Only discretionary bonuses can be excluded. And the definition of what is a discretionary bonus is very, very narrow. I'll give you an example. Over the years, employers have given holiday bonuses around the holidays, maybe $100 here, $100 there. The DOL has taken the position that if you do that routinely year after year after year, the employees have an expectation that they're going to be getting that bonus, and therefore it is no longer, quote, discretionary, and you must include it in the regular rate of pay. So as you can see, the definition of what would be a discretionary bonus is very narrow. All non-discretionary bonuses, according to this opinion letter, have to be included in the regular rate of pay. And you do that by looking at when the bonus is granted and spreading it back over the period during which it was earned, recalculating the regular rate and the overtime that might be due for the period during which the bonus was paid. So this can get quite complicated. The opinion letter goes on, however, to give you another option, which is to say that if you are paying bonuses on a fixed percentage basis, you can go ahead and pay the overtime on that bonus at the time it is paid, 1.5 times or half time the bonus, in which case you don't have to do the retroactive recalculation of overtime for the period during which the bonus was earned. So this is a very favorable employer-friendly type opinion letter, something that can help you with bonuses and avoid the complicated calculations that are sometimes necessary at year end. The next opinion letter that I think of as interest deals with the highly compensated employee exemption. As some of you know, the highly compensated employee exemption, which was people making $100,000 a year or more, but it has recently changed as of 2 days ago, and I'll get to that a little bit later. At the time the opinion letter was written, it was $100,000 a year or more. And basically what the exemption says is if somebody makes that amount or more and they perform one or more of the duties of an exempt employee, then they're exempt from overtime. So the question arose, okay, well, what if they're performing one or more of the duties of an exempt administrative employee? Do they also have to be exercising discretion and judgment with respect to matters of significance? This opinion letter clarifies that they do not need to exercise independent discretion and judgment with respect to matters of significance. And an administrative duty doesn't have to be their primary duty. So it's enough that a highly compensated employee performs some of the duties of an exempt executive, administrative, or professional employee. As long as they're making the requisite salary level, they'll be considered exempt. And then finally, in the next opinion letter that I wanted to focus on, this dealt with software that a particular employer was using for payroll purposes, and the software rounded off daily and weekly work time to 2 decimal points. So, for example, 7 hours and 35 minutes became 7.58 hours. And if the third decimal was 5 or larger, it was rounded up, and if 4 or less, it was rounded down. Basically, what the DOL says is this type of rounding is acceptable as long as over time the employee ends up getting the overtime that they would have gotten otherwise, or they would have been paid for all hours worked as they otherwise would have been paid. And it's long been their policy to accept rounding practices, as you all might know, just as long as the average over a period of time works out to where the employees are compensated for all time that they actually worked. So this basically takes what has been the rule for a long time and says, in today's digital society, when we can calculate things down to the 2 decimal points, it's fine to round like that. No problem with it at all. You can use that kind of payroll software. Okay, so we've talked about what's going on at the DOL, some DOL opinion letters. Let's look a little bit more closely about what is a hot issue these days, particularly in the courts where we're seeing a lot of lawsuits, and that is overtime. Let's start by talking about how is overtime pay calculated? I mean, all of us think in terms of, well, it's time and a half, right? But time and a half of what? Well, the law says it's 1.5 times the employee's regular rate of pay. Now, one might quickly jump to the conclusion that that's the employee's hourly rate, but it is not. The regular rate of pay is the total compensation earned by the employee during the work week divided by the total number of hours worked in the work week. The employee is then entitled to 1/2 of that amount for each hour worked over 40 in the work week. They've already been paid the straight time by receiving their total compensation for the work week. They're entitled to that extra half time as the overtime premium. So that's how overtime is calculated. Now, a moment ago, as you can see in the next slide, a moment ago I mentioned that discretionary bonuses could be excluded from that regular rate of pay. But as I pointed out, that exclusion is very narrow. You have to include any bonuses that are based on productivity, based on hitting goals, safety, attendance, or basically based on anything other than your whim. Any bonus that's described in a plan, you can presume, has to be included in calculating the regular rate of pay. So now you know how to calculate the regular rate of pay. This is disconcerting to a lot of employers. And as you can see in the next slide, one of the reasons that it's disconcerting is that if we have to include all kinds of benefits and bonuses and everything in the regular rate of pay, some employers are choosing not to provide certain benefits because they're not sure if it's going to increase the regular rate and overtime. So what the DOL is looking at is revising the definition of the regular rate of pay to clarify that certain perks or benefits get excluded from the regular rate of pay. And as you can see in the next slide, some of the things that they're thinking of excluding from the calculation of the regular rate of pay would be things like tuition reimbursement, the value of an employee discount, employer-provided gym benefits, wellness programs, reimbursed expenses, and different types of services that are provided for the employee, which might otherwise be deemed to be included in the regular rate as part of the employee's total compensation. So this is something for you to keep an eye on, these proposed regular rate rules. They would be very beneficial to employers if these items were excluded. It would allow you to grant more perks and benefits without the concern that you're, in essence, increasing overtime premiums and increasing your labor costs. Okay. The next slide is a critical one in this presentation, so I'm going to spend a good bit of time on this. This is the new salary basis rule. Any of you who have been following this issue of the salary basis for exemptions under the Fair Labor Standards Act know that this has been a very hot topic for at least 2.5 years. It really began with the Obama administration proposing to raise the salary level, the minimum salary level for somebody to be exempt from $23,660 to $47,476, almost doubling the salary basis. There was an outcry. Chambers of commerce were up in arms. Lawsuits were filed. Eventually, an injunction was issued that precluded the Obama administration from implementing that rule. Subsequently, under the Trump administration, the DOL started rethinking the rule, rethinking what would be an appropriate minimum salary, asked for public comments, and just Tuesday of this week, day before yesterday, finally issued their new salary basis rule. And what they have done is to increase the minimum salary from $455 a week to $684 a week, or as you can see in the slide, from $23,660 to $35,568. So this is a significant increase, but not nearly as large as it would have been before. So effective January 1 of this coming year, if somebody is not receiving a salary of at least $35,568, they can no longer be classified as an exempt executive, administrative, or professional employee. So you need to take a look at people who you have classified as exempt and make sure that their salary is meeting that $35,568 minimum level. The other thing that they did as part of the new salary basis rule is they increased the minimum salary for the highly compensated employee exemption from $100,000, which I referenced earlier in regard to that opinion letter, to $107,432. To make it a little easier for you to meet the new salary basis rules, they've provided that you can use non-discretionary bonuses and incentive payments that are paid at least annually to satisfy at least 10% of the salary basis. So this is helpful to those of you who have people who are paid base salary plus some sort of an incentive or commission to make sure that they get up to that minimum salary level to qualify as exempt. Of course, For anybody to be exempt, they not only have to meet the salary basis test, but they also have to satisfy the different duties tests that are in the law. So they have to satisfy the duties of an executive, administrative, or professional employee in order to be exempt. One last thing of note here, under the proposed rulemaking that the Obama administration had done, the minimum salary would have been increased automatically based on cost of living each year going forward. There is no automatic increase in the salary basis as implemented under this new rule. It will be $35,568 until such time as the DOL wage hour division acts again. There may be challenges to this new salary basis rule, but as there always are, I'm sure some organization will be opposed to it. But notwithstanding those challenges, it's probable that it will be effective January 1, 2020. One thing I will point out here is if you have individuals working for you who have been classified as exempt from overtime, but you're a little uncertain about whether they're truly exempt, they're falling into one of those gray areas, this might be a good opportunity for you to convert them to non-exempt and start paying them overtime without raising red flags. And I say that because when you do the conversion, you can simply point to this rule and say, well, I'm having to convert you because there's this new salary basis and we're not satisfying it, and so I've got to start paying you overtime. So it doesn't signal that you may have been doing it wrong all along and not paying them overtime. So if you've got people who are in a gray area in terms of classification, this is an ideal opportunity to try to reclassify them as not exempt without sending a signal that they may be entitled to overtime retroactively. Okay, enough on the salary basis. Let's look at some trends in class actions, some of the things that we're seeing, and I'll move fairly rapidly through these. One area where we're seeing a lot of cases is in the area of pay equity, basically equal pay for equal work. We're seeing class actions under both federal and state laws alleging systemic discrimination against women. Recently, a multinational retail footwear corporation, which will remain unnamed, was sued by several former female employees who alleged that they were paid less than their male counterparts, held back from promotions, and that the company had mishandled complaints of sexual harassment. So it's kind of connected with the Me Too movement that we're seeing these actions. But I've long said if I ever did plaintiff's employment side work, I would do exclusively equal pay work because so many companies are vulnerable in this area just because historically women have been paid less than men. The plaintiff's bar, which I'm not a part of, has picked up on this fact, and they've started bringing a lot of class actions in this area. One noteworthy one you'll see in the next slide that you may have heard about in the news was the U.S. women's soccer players who recently won the World Cup has sued the U.S. Soccer Federation, claiming a violation of the Equal Pay Act and also a violation of state law. And they point to the fact that while they're ranked number one in the world, they're making just 38% of what the men's team members have been making. They're also alleging unequal compensation in tryouts where they're paid far less than men. And same is true with performance bonuses. So that's just one example of this type of litigation that we're seeing. You might consider doing a pay equity study internally at your corporation just to ensure that you're not vulnerable in this area. If you do embark on such a study, however, it's highly recommended that you work with your legal counsel to keep the findings as privileged as possible under the attorney-client privilege so that they wouldn't be discoverable in litigation. And of course, if you find that you have vulnerability and exposure, make the corrections necessary so that there is not the inequity that can lead to lawsuits. Another area that we see a lot of litigation and a lot of class actions is off-the-clock cases. And basically, these are employees who are saying that they were forced to work off the clock. Many times, you get a disgruntled employee who is looking for a way to sue. They don't have a contract of employment. They don't fall into some protected group where they could claim discrimination. They never blew the whistle on anything. So their lawyer says, well, how did you get paid? And they start exploring that, and they find out that, well, they showed up 10 minutes early to work to get dressed, and they had to stick around afterwards to get undressed from their uniform, and sometimes they were sent to travel places during the day. They had to work through lunch. They worked remotely but didn't have any way to input their time, so it wasn't all captured. So that'll set off a lawsuit by the employee on behalf of themselves and all others similarly situated at your company for all the time that they worked when they were, quote, off the clock. And of course, they'll remember that their supervisor told them to work off the clock, making it a willful violation and making you responsible for 3 years of back pay rather than just 2 years. I'm being a little bit sarcastic here, but this is frankly how these things play out. You can see in the next slide some of the industries where we're seeing a lot of these off-the-clock class actions. Really touches on all different fields, but typically hourly workers, many service industry employees, typically lower wage earners are filing these types of claims, and we're seeing more and more of them nationwide, in particular California, New York, and Florida. Another area where we're seeing a number of class actions being filed is under the FCRA. Now, you're probably thinking, FCRA, what is that? Florida Civil Rights Act? No, that's actually a good guess. But what we're talking about here is the Fair Credit Reporting Act. So the next thing you're probably thinking is, well, I don't do any credit checks on my employees, so how are we talking about the Fair Credit Reporting Act here during this webinar this afternoon? Well, as many of you may know, the Fair Credit Reporting Act regulates employers who do background checks on applicants or employees when those background checks are done through a third party. So if you hire a third party to do background checks on your applicants or employees, you have to get consent from the applicant or employee for that background check. And if it turns up information that you're not too thrilled with, you then have to give the applicant or employee a, quote, pre-adverse action notice, allowing them time to explain what you found. And then finally, if you decide that you are going to take adverse action based upon what you learned, you have to give the applicant or employee an adverse action notice. With those notices, you have to give a formal notice that's prescribed by the law and a copy of the report. So as you can see, it's a complex, highly technical statute that's easy to violate. Unfortunately, the statute allows for the recovery of statutory damages, actual damages, punitive damages, and, you got it, attorney's fees, which can easily reach into the 7 figures. So plaintiffs' attorneys have discovered that, hey, most employers make mistakes here. This is a very fertile ground for bringing class actions. We can sue for all the minor technical mistakes that they made along the way and make a lot of money. So we are seeing a lot of actions being filed under the Fair Credit Reporting Act. I bring this up, there is as you can see in the next slide, a growing split among the courts as to what can be recovered. But it's a good time for you to take a look at your notice forms, maybe working with Alpha staff, and make sure that you are compliant with the law, that you are literally dotting your I's and crossing your T's so that you do not end up in one of these class actions. So you can see 3 different areas that we've talked about where we're seeing a lot of class actions on a national level. This is keeping we defense lawyers very busy. That should concern you and should hopefully make you focus upon your organization's practices in terms of equal pay, overtime, and finally, the Fair Credit Reporting Act. All right, let's shift gears here a little bit and talk about the U.S. Supreme Court what's on their agenda this fall, and in particular, Title VII. As you can see in the next slide, when Title VII case is brought alleging discrimination, the employee has to prove that they belong to a protected class, that they were qualified to do the job, that they suffer an adverse employment action, and that they were treated less favorably than other similarly situated employees that were outside of their protected class. Now, when the law was passed in 1964, Congress said that you could not discriminate against individuals based on race, color, religion, sex, or national origin. Subsequently, the Supreme Court has expanded the definition of, quote, sex in the law to include a prohibition against sexual harassment, which you all are very familiar with. When you hear about sexual harassment lawsuits, typically they're brought under Title VII. Now, under Title VII, those are the protected characteristics. But state and local laws have begun to expand the protected classes beyond race, color, religion, sex, and national origin. For example, here in Florida, we also have prohibitions against marital status discrimination, ancestry discrimination, sexual orientation discrimination, discrimination based on gender identity. And those are the trends we're seeing nationally. As you can see in the next slide, some states and municipalities have begun to ban discrimination based on sexual orientation and gender identity. The EEOC, interpreting Title VII, has said that discrimination based on sexual orientation or gender identity is discrimination based on sex that's prohibited by Title VII. The Department of Justice, on the other hand, has said that Title VII does not include sexual orientation or gender identity, and any change needs to be legislated by Congress, not the judiciary. Presently, there are 3 cases before the U.S. Supreme Court. Oral arguments going to be heard on October 8th, so this is right around the corner. 2 of the cases involve sexual orientation, and the 3rd case involves gender identity. In all 3 cases, the employers are accused of discriminating against LGBT workers. So what the Supreme Court is going to be faced with is the question of whether Title VII's prohibition of sex discrimination was intended to and covers discrimination based on sexual orientation and gender identity. It's going to be interesting to see how they handle this issue. Justice Roberts has recently made a comment in an interview that he did to the effect that it was unfortunate that Congress was not fulfilling its responsibilities in dealing with issues like this and was forcing the courts to resolve the issues. So that signals some reluctance to do what the court may perceive Congress's job to be. But it will be interesting to see how they handle it. And notwithstanding what they do, there are many state and local laws that prohibit discrimination based on sexual orientation and gender identity. And it's something that obviously we as employers don't want to do and want to comply with those laws. We don't want to discriminate based on sexual orientation or gender identity. So interesting legal issue, I guess maybe just for we lawyers, but it's something you should be aware of. Okay, let's take a look at some big wins and losses. The first one is a very significant win for employers. There was a case before the Seventh Circuit Court of Appeals where CareFusion had published maximum experience requirements in a job posting. So basically, they said, we're not going to hire anybody who has more than X number of years experience in this type of job. In effect, they eliminate a lot of older applicants by setting an experience maximum. They were sued by applicants who claimed that that type of job posting had a disparate impact on older workers. The Seventh Circuit Court of Appeals has said that the ADEA does not prohibit disparate impact in connection with job postings. So this certainly expands the rights of employers to seek less experienced workers. Now, of course, this is just one Circuit Court of Appeals, but it is a good indication of what we might expect. Basically, the court's being reluctant to expand the ADEA to include disparate impact claims by applicants, something for you all to think about. Now, on the not so good news front, there are a couple of slides here, and I will just go through these real quickly. The EEOC has been very active suing employers claiming discrimination. It's almost as though they've woken up to the fact that Congress is second-guessing their usefulness, and they've decided that they better do something productive here rather than just push charges through finding no cause. So they are bringing a lot of lawsuits. You can see a number of them here, one against the University of Miami, another one against Tapioca Express, where the company's paying $102,000 as a settlement. There was a case against a Piggly Wiggly store where the grocery store chain had refused to act when two female employees complained about sexual harassment and ultimately fired them. There was a settlement of $50,000 there. In the next slide, you can see a couple more lawsuits, one against American Security, another one against Medtronic, and finally a settlement with Kier America Corporation. In the next slide, another large settlement, a $200,000 deal they cut with KinMed LLC and PMR Virginia Holding to end a disability bias claim. So the EEOC has been very active in litigating. If you have any correspondence back and forth with the EEOC and you're on their email list, you, like me, have probably been getting emails almost on a daily basis with their press alerts as to all the settlements they're doing around the country. So they are very active, representing employees and protecting their rights under the law. All the more reason for you to be careful in your hiring decisions and be sure to work with Alpha staff when making any decision that would have an adverse effect or adverse impact on a particular employee or group of employees. Okay, let's turn our attention to the EEO-1 pay data reporting requirements. The next two slides kind of outline the history of this debate. Basically, as you all probably know, for years, the Equal Employment Opportunity Commission has required that employers file a report called an EEO-1 report, where they list the number of employees in different job categories and break it down by gender and also different race classifications. So that's a long-standing requirement. In 2016, under President Obama, the EEOC announced that it would start collecting compensation data. And they did that because they wanted to begin focusing on this whole equal pay issue that we talked about earlier. Since that announcement, there's been litigation back and forth, and I won't get into the details here. You can see the timeline in this slide and also in the next slide. But long story short, U.S. District Judge Tanya Chuckman has revived the rule and said that the EEOC's collection efforts are going forward, and employers are going to have to file compensation data as part of their EEO-1 reports. As you can see in the next slide, the agency did begin collecting Component 2, or compensation data, for 2017 and 2018 in July of this year. Their help desk is now operational, and that data for 2017 and 18 is due by the end of this month. Those of you working with Alpha staff probably know that this is something which Alpha staff is doing on your behalf. They are taking care of this reporting requirement. As you can see, it can be quite burdensome too. But it's good for you all to know that the rule has gone into effect. The EEOC likely will start looking at compensation data, trying to identify companies who have pay equity issues, and perhaps prosecuting as a result. Another trend that's worth noting, we all know about the Me Too movement, and issues concerning sexual harassment, people coming forward, making claims. But when they come forward to make claims, a lot of them find out that they have an arbitration agreement with their employer, and they can't go to court. They have to go into arbitration. So as part of the Me Too movement, a number of states and municipalities have begun to ban arbitration agreements that relate to sexual harassment claims. Now, from a legal standpoint, as you can see in the next slide, any limit to arbitration that's put in effect by a state law is probably going to be overridden by the Federal Arbitration Act. There will be likely decision from the Supreme Court striking down any state law that interferes with arbitration rights of employers under the Federal Arbitration Act. That said, you should be aware that there have been federal attempts to alter the Federal Arbitration Act, including a bipartisan effort, and we don't see many of those these days, that would create a carve-out for sexual harassment. But none of these federal attempts or bills that have been introduced have succeeded. While many states would carve out exemptions, others are proposing exempting all discrimination and harassment cases from mandatory arbitration. So we're starting to see a little bit of pushback here. This is significant because, as you can see in the next slide, more than half of non-union companies have arbitration procedures or mandatory arbitration agreements in place. That said, some of the larger technology companies have recently been bowing to employee pressure and ending their forced arbitration programs. We're seeing that type of thing at Microsoft, Google, Facebook, the companies you would expect to be rethinking arbitration given the Me Too movement. So this is a significant development. If you have arbitration agreements in place, I think you can rest easy. They're likely very difficult to challenge given current law from the Supreme Court. That said, you should be aware of this trend, then start thinking about alternatives down the road that you might consider. Okay, the last thing I want to touch on this afternoon are a couple developments on the labor front. And when I say labor, I mean traditional union management, labor, National Labor Relations Act type issues. The first development was in May of this year. The DOL has issued a new poster which includes an 800 number for employees to contact the National Labor Relations Board if they feel that their rights under the National Labor Relations Act are being violated. I point this out just simply a heads up. You need to make sure that the poster that you have in your workplace is a current poster that has that 800 number in it. In case you do have a visit from any federal agency, be it OSHA, the EEOC, the National Labor Relations Board, or another agency, they'll often ask to see your poster. So make sure you've got the most up-to-date poster in your workplace. And this is the same poster that covers all of the federal laws that you're used to seeing in your workplace. The next development on the labor front comes in the area of protected activity. Recently, the board has begun narrowing the circumstances under which a complaint made by an individual would be considered concerted activity under Section 7. And they've recently set out a 5-factor test to determine whether a statement made at a meeting in a group setting or where an employee was seeking to initiate, induce, or prepare a group for action, or whether it would qualify the individual activity as concerted activity. So there's this new test to help determine whether or not certain activities by employees, speaking up in meetings, etc., qualify as quote-unquote concerted protected activity under Section 7. This is an area where there have been a lot of expansion in the law under the prior administration, and the board's trying to rein it back in and just say, look, not every time an employee speaks up in a meeting is that concerted activity. It takes a little bit more than that. They need to be working in concert with others when they speak up. And then finally, the board has been looking at the definition of independent contractors. One of the things they've clarified is that the law, the National Labor Relations Act, does not cover independent contractors. Therefore, they cannot unionize and they can't file unfair labor practice charges. They've recently found Uber drivers to be independent contractors and not covered by the law. And finally, they recently determined that because independent contractors aren't covered by the law, if you misclassify them, that's not an unfair labor practice. So some very favorable developments out of the board on the labor front. So that's the last area that I wanted to cover today. We've covered a lot. We've talked about an employment update, changes at the DOL, various types of class actions, the Supreme Court, what's going on there, some developments with the EEOC, and finally arbitration and a labor update. A lot of material. I know it's been fast and furious, but I hope you've picked up some good tips today. And if you have any questions, I'll be happy to try to answer them at this time.
Oddly enough, I see no questions. So, people may be feeling like I am, like, wow, there's a lot going on. I sure appreciate your time in going through these things for us. And I do see a question. Let's see. Can you make an employee work past their 8 hours of work?
Okay. That question is dependent upon state law and local law. Some states have limits on the number of hours that employees can work in a day, and others do not. The same is true with certain municipalities. So, we would have to know exactly what state you're talking about, what city you're in, and then have to check those laws in order to give you a definitive answer. If you have a question along those lines, check with your Alpha staff representative and we can get you an answer, I'm sure.
Okay, and that person did throw out they are in that wonderful place out there in the West in California.
There are very significant restrictions in California on maximum number of hours that can be worked in the day. There are very restrictive break requirements as well, even within the daily requirements. So I would highly recommend that you check with Alpha staff as to the specifics.
Yeah, California. We have a couple of HR account managers out there, so definitely speak to Amy or Suzanne. If by chance those are not, either of those are not your HR account manager, I'll show you a slide here in a moment of an email address you can reach out to. And I did get a question, if a copy of the slides, I'll address that in just a moment, but I don't see any more questions. So I'm going to move on just to thank you all, first of all, for being with us, and you too, Don. Copies of the presentation are available, and you can either call our main number, 888-335-9545, or email us at HRSC, that's HR Service Center, at alphastaff.com, or again, you could speak with your HR account manager. If you are interested in our next webinar, please make what I started to say. Let me back up here. If you are interested in getting the HRCI or the SHRM credit, you can also do that through any of those mechanisms. Email the HRSC at alphastaff.com, give us a call, or ask your account manager. And then definitely, I know you've got to be interested in our next webinar. We have Pam Nading, who is a big part of why we got a wonderful award for 28 outstanding performance with our unemployment management. Pam is one of our claims consultants and heads up the team, and that's on October 24th at 2 p.m. And you notice it says that Jackson Lewis attorney discusses. Obviously, that's in error. Don, I don't know if you're available October 24th, but you're certainly welcome to join us.
I would love to help, but I don't know that I'm the expert you need.
Well, I appreciate it. And again, I want to thank everybody, and especially Don, you, for taking the time to spend with us today. And everybody.
My pleasure, Sandy. Thank you.
You're welcome. Thanks.
Thank you, everyone. Bye-bye.
Bye-bye.